So I had one thought about the framing of it, but then also a question about how there might be multiple statutes that are affected by the original meaning. So the first is dividing unconstitutional actions and unconstitutional statutes, which I think might be conceptually different, at least how I view it, is I wonder if, with respect to statutes, what you're proposing is not really a prospective overruling, but more of a perspective overruling. Is that you're not saying we will overturn this statute next time we get it, but we'll enforce it this time. You're saying we are going to look at these kind of statutes differently in the future. And so it's more perspective rather than prospective. You're overruling a perspective of looking at the statute rather than prospectively overruling the statute, or overruling the decision and holding the statute unconstitutional. The other is, just a point of clarification. A couple of times you said, we'll only apply this new original meaning in future cases, and I wonder how that affects when you have multiple statutes that are affected by the same constitutional original meaning. So in decision A, you say, yes, they got the original meaning wrong, this is unconstitutional, but this particular statute has a ton of reliance costs, so we're only going to enforce this original meaning in the future. Well, what do you do when you get another statute that was enacted before decision A, but that hasn't engendered the same kind of reliance interests? Does that get buttressed into the first decision, or can you relook at those reliance interests and say, okay, even though we were only going forward, this one doesn't have the same protection as the statute we first looked at?
All right, I guess I'm the second Tyler. I love this paper. It spurred a lot of thought and a lot of reactions. So I want to share briefly 4 reactions. The first 2 were surprises. I never took you as great fans of the Warren Court. It's good to see that you love Miranda and MAP, as Rick highlighted, and all that law that they were able to put in place before Griffith versus Kentucky shuts that down in 1987 and says everything is retroactive now. So that was a surprise. The other surprise was hearing that in defending the Article 3 inquiry, the fact that this issue didn't come up at the founding sort of frees you a little bit, because that was refreshing to hear, but not something I thought I would hear. Or maybe I misheard that. Okay, now 2 points, additional reactions. The first is, isn't this already happening, just in a different way? So do you even need this? What do I mean by that? All you have to do is read Clarence Thomas's separate opinions, which used to be dissents but now are concurrences, to see where the law is going. And if that's right, and I'm being quite serious, do you really need this? If he's already sort of saying, okay, Obergefell is vulnerable, Griswold is vulnerable, New York Times versus Sullivan is vulnerable, is that enough? Do you need to go further? So that was one question. Neil Gorsuch writes opinions like this as well. Brown versus Allen seems to be in jeopardy on his view. And then the final reaction I had was one of how this fits into the larger historical fabric of constitutional law in this country. And you could imagine one answer, which John offered in presenting the paper, which is, by giving advance notice that the law is going to change, we allow social mobilization of movements in order to respond and push for amendments. But one could also potentially say, and I wonder if you want to speak to this, that if we've had a series of decisions on which people have relied in the past, they have assumed over time that there wasn't a need to amend the Constitution. And if we're going to engage in, I think the word you used was revisiting an enormous number of decisions, is it really fair to say on all of these different planes people need to react in real time and amend the Constitution, when for, in some cases, generations, they've assumed that was unnecessary? But maybe if in real time we'd had purely originalist decisions decades ago on various issues, there would have been a movement for amending the Constitution then. There's just been a longstanding assumption that wasn't necessary, and now the Constitution means something else.
So this connects a little bit with Amanda's third point. and this is really just a constructive suggestion, in the paper there's a lot of energy spent on establishing that one of these prospective overruling decisions would actually be a holding rather than dicta. And I wonder whether you need that discussion at all. So maybe one way of getting at it is to ask, is the only implication of that discussion that the lower courts would be controlled? So if you think about the horizontal context, where it's the Supreme Court deferring to one of their earlier decisions, I think in that context you have two scenarios. In scenario one, the later court agrees with the earlier court. Maybe it's because the exact same composition, or maybe it's just because they had the same views on the earlier decision. In that scenario, stare decisis is doing no work because the later court just agrees on the merits with what the earlier court thinks about the original Constitution. The other scenario is one in which the later court disagrees with the constitutional reasoning of the earlier court. But in that case, I think it's unlikely that the later court is going to defer to a prospective overruling decision, because they're going to disagree with the content of the earlier court's decision. And then because this is purely a prospective overruling decision where they've just announced their views, but they've actually not done anything to the law underneath it, there's not going to be any reliance costs. There's not going to be any pragmatic consequences that they need to worry about in disagreeing with the earlier court has said. So I think what follows from that is that there's really not much implication in the horizontal context. And then you do point out that, in the vertical context, well, it may be that if you treat this as a holding, that'll have some implications for how the lower courts think about this. But the paper treats that as if it's a fixed point, when, most of the rest of the paper doesn't treat rules of stare decisis as fixed points. And so I just wonder, whether this whole project could work by simply just saying that, the Supreme Court should announce this in dicta, and that when they do so, lower courts should be deferential to that dicta.
We do think this would work as dicta, but we don't think you have to rely on that. And I think a lot of people would be, I'm not sure as a constitutional matter or otherwise, but they would feel more comfortable if this wasn't dicta, and we actually don't think it's dicta. So that's part of the reason why. But you're right, and we argue that as a practical matter, you could basically have much the same system with the small changes that you mentioned with respect to that. And then I'll just take some of these, and I'll take the ones I want, and you can have the rest. With respect to the Warren Court, the big difference, of course, being that the Warren Court was engaged in living constitutionalism, and of course we're engaged in returning to the original meaning. I don't think it's simply true that this didn't come up at the founding, although I think it's basically that the judicial power does not incorporate, virtually all the common law rules that existed at the time. So we've got that point, and then the question is there a counter argument that didn't exist at the founding? Well, no, most common law rules are not incorporated otherwise. Why don't you jump in, John?
Okay. Let me talk about another point about that Amanda made, which is the worry about people may have relied on these rules for a very long time. There have been no social movement. So one point, I think, in our earlier work, we do not think this is the only precedent rule. So for instance, we have a rule about what we call entrenched precedent. So if the court thinks, for instance, that there is now a kind of consensus in favor of the position in the society equivalent to a constitutional amendment, well then that they should follow that as well. So this is not our only rule, and that's a rule that really tries to take account of the fact that we don't want to necessarily force people, movements that have considered something settled in that way. But there are a lot of precedents that are not settled in that way. And there, it's important, I think, to return the Constitution to the people, to actually put social movements through their paces. So it's important to understand this in the context of our entire view of precedent rules. I think the point about making a clear distinction between actions and statutes, I think is well taken. I think we might want to do that. Your question, I also think, is an interesting one. Well, what about how do we look at statutes? Do we look at statutes that maybe were passed beforehand but don't have in themselves much reliance costs? I think really goes to a kind of question of administrative ability of our rules versus going statute by statute. I mean, of course, even with respect to the Warren Court, you could have made distinctions about different times. Well, maybe it was 2 years ago or 3 years ago. Really wouldn't create enormous costs if we started the time then. We have to think about exactly how we carve out time and statutes to make them to make these administrative questions, I think, a little more tractable than just saying, well, everything's up for grabs on an individual basis. So those are the kind of answers that I think I would give to you.
I just want to add in one point. So John's remarks didn't get into it, but part of what we do in the paper, and something I'm particularly a fan of, is combining prospective overruling and cutting back. There's the whole notion of cutting back here where if a retrospective overruling would lead to enormous costs, you may not necessarily have to go all the way, you might, but a more moderate overruling that got you closer to the original meaning, but not all the way to the original meaning, didn't get you enormous costs. You could do that, and then you would cut back retrospectively, and then prospectively you would apply the original meaning. So we've got these two techniques that together really are two tools and that can be used together, but could be used separately also to get us closer to the original meaning.
I love this paper. Risk of shocking the room, I love this paper. I thought it was terrific. I think we all agree, I hope, that this is an under-theorized part of originalism. What do we do with non-originalist precedent? Lee Strang's book, which I recently reviewed, I think Lee's version of this is not as good as yours by any close. So my comments are for suggestions. I would like to think that your goal in this eventual project is to convince both originalists and non-originalists that this is the way the Supreme Court should proceed in the future. In other words, you're trying to convince people who don't necessarily buy into originalism. I would hope that's what you'd want to do, since that's half the Academy or 80% of the Academy. So with that notion, the supermajoritarian idea that you put in this paper that comes from your book, I think that's a real distraction, because where I come from, in the circles that I travel in, we don't buy that at all. It was not a supermajoritarian process at all. Only white males were involved in it, and I guess maybe even white property males back in the first time. So you don't need it for this article. And I think the fact that you just allude to it quickly and kind of move, is very distracting to someone who doesn't buy into the premise. So I would suggest you take that out. And then someone who is coming to this table with no view on originalism at all, just agnostic. You say numerous times that there's so much non-originalist precedent. Well, that's going to make someone else who say, wait a minute, if there's that much non-originalist precedent, maybe these arguments for originalism have less weight. I don't think you need to say it 15 times, or how many times you say it in the paper. We all know there's non-originalist precedent out there, but the more you stress that, I think, it raises some doubts. And then the last thing I want to say responds it's not extra legal, Rick. It is not extra legal for a judge to say, what are the costs of overturning this decision if the legal rule, if the Supreme Court bought their approach, said, we agree with John and we agree with Mike, and it's a great theory and we're going to do it. I don't think that's extra legal at all. I think there are many areas of the law where we take consequences on the ground into account. And again, I raise that because I think this paper is a great effort for originalists and non-originalists alike. So all of these suggestions were just to get non-originalists to take this paper seriously. And I really commend this approach. I really do.
So I also found this paper more convincing than I expected to, maybe halfway convincing so far. And right now it's kind of trying to disprove the negative claim that prospective ruling is unconstitutional or violates Article 3 of the case or controversy requirement. But I would like to hear more about sort of the positive claim about how we can legitimately or lawfully get from here to there, which goes into some of the things I know you've written before about sort of precedent rules as common law and how do we get from our current precedent rules to different or ideal precedent rules. But I think this is really sort of putting that to the test. So one possibility is that you think our current rules of precedent permit this perspective of a ruling regime, and the court should just do it. But the other possibility is you think our current rules of precedent don't give a wide range of perspective of ruling options because we got rid of those in the 90s, and the Supreme Court would have to change the precedent, change the precedents about precedent to get us to this perspective of a ruling regime. And so I'm curious, which of those is it, and why, if it's the second one, why is that okay? Is it okay for the Supreme Court to just come in and take the law of precedent and make new law of precedent that it likes because the Supreme Court is a lawmaker of some kind? Or is there some better story that gets us from here to there?
My question is sort of building on Professor Kay's comments and Professor Bode's questions, is about sort of the theory of precedent that's being articulated here, the positive theory of precedent, and sort of its whether or not it has an originalist pedigree, the original meaning versus the enormous costs, and where that balance or where that comes from in either the original method of adjudication or the original law of precedent. My understanding was that the judicial power was like retroactive adjudication of specific cases or controversies, particularly with respect to private rights, and that what was really binding was a judgment. That was binding was the judgment on the parties, and that anything else wasn't, in the opinion, wasn't binding on future courts. And then that would depend on, if precedent is just a semblance of law, then we're bound just by the law, not by any previous precedent. If there's a demonstrably erroneous standard, or if it's some kind of pragmatic exception. And so I'm wondering, do you have sort of a larger theory of precedent, originalist theory of precedent, original method of adjudication with respect to the law of precedent that this paper comes in under? And what that theory of precedent is, if it's something like that we're just bound by law and precedent as a semblance, if it's demonstrably erroneous, or if it's some kind of pragmatic exception. And so what that theory of precedent is and how it maybe responds to other views about the original method of adjudication and the original law of precedent.
So, I suppose there's a bit of a dilemma about talking about our normative theory. Because on the one hand, we have this normative theory, and we feel like it allows us to balance the benefits of the original meaning against the reliance costs, and that's we like it anyway. And obviously then, if we don't talk about that theory, it's not really clear why enormous cost is the right standard, and why even one would care about I suppose one could just assume one cares about the original meaning. So, so it's in there to kind of make for a more sort of theoretically, more theoretical approach, consistent with our theory of consequentialism. But I obviously, I take your point that some people may not quite agree with it. Will, I guess, so we think of the Warren Court precedent rules as, first of all, being quite different. It's about changing the law, and the departure from those. The only holding we get has to do with selective prospective overruling. So there's no holding we would require that one overturn. Now, the rules we recommend are not out there now. But I wonder whether or not it's a question of circumstances, right? So now, you know, we don't have originalism operating in the 1960s. So now we've got a jurisprudence which is looking that sees the original meaning as being very important. And the question is how are we going to get there? I would say this is a new circumstance, and so the fact that we don't have these rules applying in the past is largely because people were not interested in originalism. So we've now got a new part of the law, and so the law applies to new circumstances. So I don't know if you call that a new common law. I mean, maybe it's a sort of semantic thing. I would say it's principles that are not inconsistent with the earlier law, and maybe implicit. Well, maybe that's a little bit strong, but not inconsistent and perhaps somewhat implicit in the earlier law.
So the only thing I would add to that is we certainly see the court doing something similar, I think, in the qualified immunity context, right? That it suggests that to make sure the constitutional law isn't stagnant, we do it in a series, we structure it in a series of ways. And I think at least we see generally the court changing rules of standing, prudential standing over time. And I understand the argument is, are we, something implicit in your question, are we going back to the bad realist idea of the common law rather than the general law? And I think Mike's answer is, well, we're really just looking at changes in circumstance. But I think there's some reason to believe that there's some more room for the court to change the rules that are connected to the judicial structure rather than changing the cost-benefit analysis to rules of tort and that. And I think we see that, at least. That's a pretty good description, it seems, of what the court does with rules like standing, rules like the order of procedure in Saussure. So I don't think what we're suggesting is really an outrageous departure from norms. Indeed, one thing that we learned after this paper was sent out is actually there's currently a debate on the court about prospective overruling between Kavanaugh and Gorsuch in a recent case. So at least they think that's still live on the table of these pure prospective overruling. So we're actually not arguing for a dramatic change in the law.
And I guess one other thing I would sort of say is I think we're at least agnostic on the at least for purposes of this paper, as to the issue of whether or not it's under our existing common law, whether judges can change the common law. Judges are changing the common law all the time, and if the common law is in part understood as practice, then maybe that's the new common law, even if. So that's a possibility. We're not endorsing that, but we're not. The paper's really sort of agnostic on that point. So, anyway.
If this is prospective as to future statutes, what happens when you amend an old statute? So we drop the punishment for the felon in possession statute from 5 years to 4. Is the new statute unconstitutional? Is it left in place because it's amending something that we're leaving in place? What do we do with that? More generally, I didn't see discussion in the paper about Northern Pipeline, and I'm wondering what you think about other mechanisms. So could the court, for example, instead of monkey around with the precedent rules, just say, look, we're just going to delay the mandate and keep all these cases for the next 2 years, but we're telling you what we plan to do with them so that if you want to amend the Constitution in the meantime, go ahead. Is there a reason why one strategy would be better or worse on your grounds than another? Do you have any opinions about other mechanisms that might be out there that are not prospective overruling? Thank you.
I really like this paper, and I'm largely convinced, at least by the basic proposal. So I have two suggestions. I hope they are both constructive. The first suggestion is that I believe that the audience for this paper the primary audience ought to be Supreme Court justices and originalist judges on the lower courts, that you have a real chance to convince them, and so your first outing ought to be aimed at them. I think that has consequences for several things in the paper, one of which is being more ecumenical about justifications for originalism. I would not drop your theory, that clearly should be included, but I think that the current justices are more likely to see originalism as justified by rule of law concerns, what they tend to call separation of powers or judicial role legitimacy concerns, and popular sovereignty. So I do think, and I can offer suggestions tactically for how to do it, that your argument can go through on all of these theories, and that by appealing broadly, and especially appealing to the justifications for originalism, that this key audience holds, the paper will be more likely to convince them. So the second concern or suggestion is a camel's nose under the tent concern. It's related to Rick Kay's concern about the enormous cost standard, and it could play out in various ways. One way it could play out is that once this enormous cost principle is established as a rationale for the departure from prospectivity, that it could infect other areas, so that a judge might say, well, there's no reliance problem here, but there is an enormous cost prospective problem, and we have established this enormous cost principle. So and you can imagine various other variations of that. And then there's this line drawing problem, right? So I think you're absolutely right that some cases of enormous cost are very clear on both sides of the line. But obviously, there are going to be cases in which the enormity criterion could be viewed differently by different judges based on their normative concerns. And there is a problem here of creep, that such standards tend to become stricter or less strict based on the judge's preferences for outcomes. And so this is not an objection. I'm simply saying that I think that if you address the camel under the tent concerns in the paper, that would be very helpful for many readers.
I think the paper assumes that the court will have a certain kind of continuity in personnel, which may not be a justified assumption. I mean, we saw with Justice Ginsburg's death how the shift of one justice can radically alter the trajectory of the court. And I feel like there would be a similar problem here, that you can't guarantee when the next case comes up what the court's personnel will be. And prospective overruling may not, a future court may decide not to abide by that, and that there are costs in not imposing the rule now. And that the second is, to the extent that the justification that you're offering is consequentialist in nature, one of the things I was wondering is, what about the unintended effects for law more broadly? That this might facilitate overruling bad constitutional precedent, but it also might facilitate overruling common law decisions. And you have judges that I think on the common law side today feel very unbounded by what the history and tradition is, and they just pick a rule, in the kind of post-realist view of what they, or realist view of what they think is convenient. And if they can prospectively overrule, that may diminish the cost and may destabilize the common law, even as it tries to bring some order to the constitutional regime.
So Steve, with respect to the amendment, so we actually have, and this complicates the picture a little bit, but we think that certain things would create enormous costs unless you allowed, we draw a distinction between updating a statute and expanding a statute. And so if one were to go back to the original meaning of the Commerce Clause, even if one allowed the existing statutes to operate, you could make, there's a very plausible case to be made that as circumstances change, people who've operated under those statutes will no longer be able to operate because it won't be updated. It won't be updated. It'll become out of date. And so, given the difficulties in sort of replacing the Commerce Clause regulation, we think that it makes sense to have an updating possibility where you can take the program you have, not expand it, but change it around. That obviously introduces a new distinction and increases the administrative costs. We would prefer not to do that in a case, let's say, involving the non-delegation doctrine, where there are various mechanisms that Congress could use, such as having stricter, less discretionary standards, having REINS Act type mechanisms. You wouldn't need that. So there's a kind of prospective overruling with updating and a prospective overruling without updating that would deal with that. I'll just take one more. With regard to the point about personnel, you're absolutely right. That's a change in personnel can destabilize. I guess the only thing that I would say is that if the first decision, if you buy the argument that the first decision was a holding with respect to the original meaning, then this court, which is supposed to be following precedent, or at least claims to be following precedent, would be bound by that original meaning determination. Now, whether in a realist sense they would actually follow it, is another story. But you're absolutely right. It's two steps along the way, and but that's necessary to make the system work.
Thank you. 2 quick points. So first with Larry, I think it's a good suggestion about being more ecumenical about reasons, at least in this paper, in the draft of this paper, because I do think the audience, insofar as we can persuade them, is the judiciary. Just very briefly, Steve Sachs's idea of the 2-year delay, I don't think that's as good as sort of a remedial idea. Could we do this as remedies as opposed to precedent? This, I think, is not perhaps such a good idea, because one advantage of our perspective with respect to statutes is it sort of lets it in the legislature's court, whereas there, the court is going to have to make its own judgment about how long is long enough. And I think that's a difficult judgment, and so why don't we let Congress decide, well, do we need to pass this? To the degree, then they'll move forward. To the degree they don't feel they need it, they won't move forward. The 2 years also just seems to demand the kind of knowledge on the court, and also maybe put Congress in a difficult position, because it may feel it has to do all sorts of things within 2 years, which could create a lot of strategic behavior.
So a very brief question about standing. I agree that the qualified immunity analogy is quite apt, but there are some arguments in the Camreta versus Green dissent by Justice Kennedy. So, we have Saussure says you got to address the merits as well as qualified immunity. Pearson says, well, you're allowed to address the merits. But 2 years later, Kennedy suggested, it seems to say, once you've won because you have qualified immunity, the case is over. You shouldn't talk about the merits. So it would take the Pearson rule, or take the Saussure rule and make it mandatory the other way. Scalia said he was open to that argument. So just dealing with that argument, I think, would be good.
I want to offer a cautionary thought that is outside the frame of the paper a little bit. I think the presentation of the paper is one in which the problem that your method comes to solve is temporary. That is to say, we live at a moment with a lot of non-originalist precedent, let's assume, and an originalist court, right, let's assume, and the goal is to close the gap between the non-originalist precedent and the originalist jurisprudence that this court would deliver, right? And let's assume, even per Robert, that the second condition is permanent, that it's an originalist court. The closing of the gap is still not something that's going to occur over a finite period of time, because in the future, original meaning will change, right? Not actual original meaning, right? To the extent that constitutional provisions have actual original meanings, they're facts about history. But courts decide cases on the basis of operative original meanings, that is to say, the original meaning as understood by this court today. And we know for sure that operative original meanings change and will change over time, right? What the court thinks is the original meaning of the Fourth Amendment in 2023 will not be what the court thinks is the original meaning of the Fourth Amendment in 2040, because between now and then, a bunch of really smart people in this room and elsewhere will teach us new things about original meanings, and those things will interact with other developments. The original meanings, as implemented by the courts, will change, right? So there will be a constantly receding target. And you might say, that's always the right target, so we should always use our method, right? But it's just we're thinking about the fact that the solution that you're proposing isn't a temporary solution. It's a permanent working condition.
I wonder how much the problem you're interested in doesn't involve judicial precedent. What you're concerned about is maintaining stability and a change from one constitutional era to another, and grandfathering statutes and regulations from an earlier constitutional era. But constitutional eras have both, or manifest both in judicial precedent and in Whittington-style constructions that everybody just knows that some things are okay, and so they're done, and not because they're supported by a judicial precedent, just because in that era everybody knows that they're okay. And I have a hard time seeing how the tool of saying we will leave judicial precedents in place can preserve from the earlier constitutional era statutes and regulations that are not supported by any particular judicial decision, but that were thought to be lawful because people thought that kind of stuff was lawful.
Which I think I disagree with the premise of the question, which is I do think with good faith originalism, there is a convergence towards truth. So I don't actually see, you could think that we'll just have a completely different originalist set of ideas that could be even 180 degrees different about X and Y and Z, and so that would be permanent. But if we think that originalism is a kind of incremental science that is going to work the law pure in a certain way, to be sure, there will always be some gap, but we're not going to be always in the same situation that you posit. So I think there's a kind of disagreement, I think, about the nature of the originalist enterprise, maybe between you and me, and I dare say Mike in that respect.
So my reaction to Richard's point is, well, we should have such problems, right? We've realized our originalism, and now we see, originalism continues to reign, and now we've got an even better understanding of it. So you're absolutely right. It's the dynamic aspects of the law creates additional concerns and costs, but again, we got this trade-off between the benefits of actually getting to the original meaning versus the reliance costs. With respect to John's point, so some of that I think I need to think about a bit more, but so some of the time practices are out there and they're understood to be constitutional because they're readings of the constitutional law, and people just, this is okay under the Constitution, right? They don't get challenged because no one questions it. So in those cases, I'm not sure if one treats that as a precedent or not, but obviously that's not going to be all the cases. And then the question is, do these precedent rules then apply to practices that are out there? And I'm not sure what I think about that. You could go, there's another way of thinking about, we evaluate, we theorize about all this stuff in terms of precedent rules. But people like Dick Fallon want to think about it in terms of remedial rules. So we also we have reasons for wanting to be in the precedent world. But if one wasn't in the precedent world, one alternative that just occurs to me is to be in that remedial world. We're happier in the precedent world, so I just mentioned that as a possible response. But.
Right. I think there's not always a very sharp distinction between precedent and settled practice. One of the examples we give, in fact, in the paper doesn't have a clear Supreme Court precedent, and that is, of course, the Congressional Executive Agreement. And yet, it is, look at the Restatement of International Law, it is completely accepted, and to many originalists, completely infirm. But that doesn't mean, I think, that some of the same kinds of considerations aren't in play, perhaps when something comes to the Supreme Court, to say, because rather to upend all sorts of matters that were resolved, as you say, on practices, maybe on congressional precedents, even if not in the Supreme Court. So I do think those are nice distinctions that we probably should be more cognizant of in the paper, but I don't think it changes our fundamental enterprise.
All right, well, we are a little bit beyond time, so please join me in thanking all three of our panelists. Thank you.